I'm going to make this as simple as I can. Earlier, I told you that there were basically two main documents, and that's what there was. There was a will, a last will and testament, and then there was a trust. So the last will and testament was drafted in 2000. And basically, what that document said is that Maria and Irene share and share alike. 50-50, right? So the entire estate would be divided down the middle 50-50. Both Maria and Irene, that's me, and my sibling, were to be trustees. So we were co trustees. And we were also to be personal representatives. So we were co personal representatives. And we were both co successor trustees. So that means if whoever was the trustee first, which was either my mother or my father, and if they should pass, then we would be successor trustees. And in that last will and testament, there was also a spendthrift provision that my father had put in. And what the spendthrift provision is that no part of the estate may be used to satisfy a judgment. So a creditor can't come after you and try to steal your inheritance, which is exactly what my ex had tried to do and actually was quite successful doing because nobody seemed to care whether there was a spendthrift provision or not. So to recap, in the last will and testament, Maria and Irene were both co-trustees. They were both personal representatives, and they were both successor trustees. And there was the spendthrift provision. So there was a balance of power there because no daughter had any more power than the other daughter. Well, lo and behold, all of a sudden, there was a second version of this will that appeared that included some third amendment that was really bogus. And that this second version of this will was drafted on December 24th, 2006, which is Christmas Eve. And remember, we talked about how narcissists love to kind of inflict pain on holidays. So we noticed that it was Valentine's Day or my birthday or one of my children's birthdays or whatever other holiday, Thanksgiving and things like that. And so that was just a clue for me to know that, in fact, it was a bogus document. But in any event, so that document was supposedly drafted Christmas Eve 2006. Now, what's interesting is it wasn't filed with the court until 2013. So during that 7-year period, all kinds of things could have happened, right? Maybe that document was actually drafted after my parents had died in 2010 and 2011. I mean, nobody knows, right? Because nobody supposedly had a copy of that. And in fact, the will, per Florida law, must be filed with the court within 10 days of the death. So, in fact, when my father died in 2010, in August, 10 days later, the beginning of September, his will needed to be filed with the court, not in 2013. And when my mother died in 2011, 10 days after that, it needed to be filed with the court. And yet these documents, all the documents, seemed to be filed with the court in 2013, which was long enough for all kinds of monkey business to have gone on with these documents. So let me tell you about the second version of the will that just all of a sudden, just spontaneously came into existence. And this document shows that Irene is the only trustee and that her husband, Alan, and Tom, who is the attorney, it's a cousin. He's a cousin of ours. And so my father wanted to keep things even. So it was always Maria and Irene. And then he wanted the backups in case one of us wouldn't be able to serve. Then he wanted, so Alan would take the place of Irene. And my cousin Tom, who happens to be an attorney and who was really very supportive of me, would then take my place. So it would be a balance of power. So in the second version, Irene is listed as the trustee. Isn't that interesting? I don't know what happened to me there. And Alan and Tom were backup co-trustees. And then it also said in this version that Irene is the personal representative. Well, what happened to Maria? All of a sudden she was written out, I guess. And that Alan and Tom were backup co-personal representatives. And in that version of the will, $1,000 went to Maria and to Maria's three children. So isn't that interesting? The second document of interest is the trust agreement of my parents, and that was written in 1991. And it was filed very, very suspiciously, actually, in 2015. Oh my gosh. I mean, that's amazing, right? And so what the original document says is that the entire trust is to be equally divided between Maria and Irene, to share and share alike, 50-50. Okay, and that Maria and Irene were both successor trustees, so they were co-successor trustees, right? And then there was the spendthrift provision, which is what I told you, that in fact no part of the inheritance can be used to satisfy a judgment, legal or otherwise. And of course, you know, we had the $10 million defamation judgment that Scott was just going, I'm going to get that now. And so anyway, none of my inheritance was to go to that, and yet so much of it did end up going to it. But that was mainly because I couldn't have legal representation. There was not an attorney in the entire state of Florida who was supposedly allowed to represent me. Isn't that interesting? So in this trust agreement, the estate is to be divided 50-50, and my children were not to receive their inheritance if something should have happened to me until they were 25 years old. And my father had specifically put that in there and asked me if I agreed with that, and I wholeheartedly did. And the reason why my father put that in there was really to protect my children, because he knew that Scott, the ex, was trying to worm his way into the estate. And so if, God forbid, anything should have happened to me, then my inheritance would have gone to my children. Well, if my children were minors at the time, then who would have taken control of their vast fortune that they would have gotten as young children? So my father didn't want their father, Scott, his ex-son-in-law, to kind of get his little grubby hands on their money. So what my father said is that the children would each get it when they turned 25, because by that time they'd be old enough to know how to manage their money, or at least hire someone to do that. But in fact, he wasn't then so worried that Scott would have become involved in that inheritance. So that was the First Amendment to the trust document that was drafted in 2000. And the Second Amendment, which is key here, that was drafted in 2005, on December 9th, 2005. And that was drafted 6 months after my mother was put in a facility, and 1.5 years after my father had bought me the condo, which is number 417. Basically, this document shows that number 417, that condo, goes to me. And that number 414, which is my parents' condo, that one would go to Irene. So it was 2 condos, 2 daughters. It was very, very simple. So unfortunately, when I looked at those documents, and again, this one hadn't been filed until 2015, which is rather strange, I did notice that in this document, they listed the wrong mailing address. So there was a wrong zip code. The zip code for those condos was 33767. So this one, I don't even know where this one is, 33708. Anyway, that's certainly not the correct zip code. And so for both of those sections in the trust agreement, it listed the mailing address as this wrong, incorrect zip. It also listed in mine, it listed the wrong road. and um, and also with the mail not being able to be received, then perhaps I thought, now what's the strategy there? Why did they do that? And I have my own ideas about what that was all about, and I do believe it had something to do with my parents' condo then being the subject of a sheriff's sale. And so I'm not sure exactly what that was about, but we'll get into that. In any event, in this trust, it showed that both condos were to be paid off at my mother's death. And yet, my mother and father's condo went into default. And that was never to happen because there was certainly plenty of money to pay off the mortgage. In fact, that was one of the stipulations in the trust. And my sister then said that she and I were tenants in common of my parents' condo, which is like so ridiculous. I had my condo, she had my parents' condo. But what happened was they had given my condo to my son Peter. And in Florida, you can't just take someone's only home. And so what happened was they then decided to figure this out where Irene and I would be tenants in common. And as a result of that, Irene actually gave Scott, my ex-husband, my 50% of my parents' condo. And then Irene and Scott ended up dealing with the sheriff to auction it. And what information I've been able to discern is that Scott paid $100 in a filing fee, and it didn't show any other payment in terms of the auction. But 6 months later, he and Irene together, they sold it for a significant amount of money. I think it was nearly $500,000. And in fact, it just recently sold. It was on the market for $1.1 million, and in fact, it just recently sold for $1 million. So that was very weird, actually. And in this amendment, Irene and I were to share in some of my parents' silver. I think it was sterling silver and some of their crystal and some of their finer things, along with their paintings. And they had some beautiful artwork. So we were to share that 50-50 again. And so that was all fine and good. Then all of a sudden, the Third Amendment showed up. And the Third Amendment was drafted on Christmas Eve. And it was filed on Mother's Day. So it was drafted on Christmas Eve 2006. And then it was filed on Mother's Day in 2015. And again, that one had the wrong zip for the condos, and the wrong road and the wrong zip for my condo. And then again, it had the wrong zip again, which would direct where the bills would go from the condo, so that the trust could actually pay the mortgage and other, management fees and things like that. And also, per the agreement, the mortgage was to be paid off at my mother's death. So 414 was never to go into default. And so even though it was written in both the Second and Third Amendments, it did go into default. So somehow some bill didn't get paid. And wouldn't it be interesting if all of a sudden they said, well, it didn't get paid. And the reason it didn't get paid is because it had the wrong address. And so because it had the wrong address, then it didn't get paid, and then it went into default, and then the sheriff had a sale. So that's kind of a good excuse, I think, isn't it? But in fact, there were family meetings where my father would sit us down and he'd say, now I want you to know that everything's taken care of. You're not going to have to worry about anything. You're going to get these condos free and clear. You're not going to owe any money. Each person gets the contents, the furniture and the contents of each of those. And so it's all fine. Everything is even. Now, in this Third Amendment, let me tell you, it shows that the entire trust is divided between Irene and my son, Peter, and that Alan, Irene's husband, and Tom, our attorney cousin, were backup co-trustees, and that Irene was the only trustee. And Irene claims that all the art and the crystal and the sterling and all kinds of other things that my mother wanted us to split only go to her. And then she claims that, in fact, she's also the attorney in fact, with Alan and Tom as co-backup attorneys in fact. So all of a sudden, this Third Amendment shows up that just totally deletes me out of the equation. And yet it says that it was drafted in 2006. And yet my father didn't pass until 2010 and my mother in 2011. And we had numerous times where we sat in their living room and we talked about how the trust was going to be divided, how the will was going to be divided, and everything was all taken care of. So for this document to supposedly having been drafted on Christmas Eve 2006 is just ridiculous. And all of a sudden, I'm just written out of everything. And all of a sudden, now Irene and I are sharing number 414, my parents' condo. It's very strange. So you see, it's the simplicity of it all. And here we get into the good stuff, and we see how the will and the trust were manipulated and brought before Pinellas County judges. There was an original will that we talked about, and again, it showed that the will must be filed within 10 days. And I'm repeating myself only because what I did is I did a summary before I'm getting into more of the specifics. But you'll see how that works, because I think kind of repetition is important here when you talk about legal documents. It's interesting that the will wasn't filed with the clerk of court within 10 days of the settler's death, which would have been in 2010 and then again in 2011, and yet it was filed in 2013, which is totally contrary to Florida law, from what I understand. The will said that my mother was being of sound and disposing mind and memory, do hereby make, publish, and declare this to be my last will and testament, and that I nominate Maria and Irene to share and share alike, 50% each of the estate. And I nominate both of my daughters, Maria and Irene, to be co-trustees. And I nominate both of my daughters, Maria and Irene, to be personal representatives. So you see, Maria and Irene each get 50%. They're both trustees, so they're both co-trustees, and they're both co-personal representatives, as we saw, and that's the original will. And then all of a sudden, you get the second will that totally has written out Maria. She doesn't even exist in that. It was after my mother was taken to an Alzheimer's facility. So it says, my mother being of sound and disposing mind and memory, do hereby make, publish, and declare that Peter and Irene would share 50-50. Well, obviously, my mother wasn't of sound mind and memory. I wish she had been, but unfortunately, she wasn't. Both my mother and father, during their last days, for some very horrific reason, were both isolated and monitored 24/7 and basically imprisoned and bedridden, when in fact they didn't have to be that way, because they were walking, they were talking, they were quite sharp, actually. My mother her memory was starting to go, but certainly she didn't need to be institutionalized at that time. But nonetheless, that is how it turned out, and I didn't have any control over that. That was between Irene and my father. But let's see what we can tell you about that here. As far as I'm concerned, the bogus will had the bogus Third Amendment, and which stated that in fact the entire trust estate goes to Irene and Peter. And so what we have here is that Peter's name basically has replaced mine. And it's impossible that my parents would have ever allowed Peter to inherit even any portion of their estate. And I suppose if it happened where I was no longer around, then of course my parents wanted to equally compensate all four of my children. But as far as Peter went, he drank too much. He partied too hard. That's about all I'm going to say about that. My parents didn't tolerate that kind of behavior, and certainly they weren't going to fund it. And Peter was actually, at first, though, he was the first grandchild, so he was quite the favorite, actually. But, because of his kind of entitled attitude, my father really didn't go for that at all. And because Peter had then decided to align himself with Scott and Irene, whose stalking and following and monitoring and threats kind of unnerved my parents to no end. My father really was quite upset with his former son-in-law, because my father could barely even talk on the phone because there was so much, there were so many echoes, there was so much static, there were so many dropped calls, and so my parents didn't even want Peter visiting them, actually. So for him to be inheriting tens of millions of dollars wasn't even believable. And so if the supposed heir, unless he was hiding, I never saw him come to visit my mother. He came once, and we went together to visit my mother in all those years. In the so she was put there in 2005, and she died in 2011. So that's 6 years. And one time that he came to spend the weekend with me, did we go and visit my mother. But he didn't show up at either of their funerals, and he certainly didn't call me to tell me that he was taking everything of mine. And so Peter had kind of turned ice cold on me. And although in the past he had had full access to my homes and my car and everything, beginning in 2008, 2009, when he'd come for a weekend visit, I could feel that he was on a mission to sabotage me. And I know I talked about this in one of the earlier videos, which is that after the front page story, She Must Pay, Peter said that he was getting a message from his father that either he needed to side with his father, or that his life was going to be as chaotic, yeah, as mine has been. And so, for a young man, was I understand that he took the easy way out, and yet there had to be another way. But in any event, I noticed that he was staging things in front of like hidden cameras or something, because he'd keep repeating something, or he'd start belittling me, and he'd be repeating things that just weren't true. And he was criticizing me in front of my friends when my friends would come over, and I'd tell them that my son was coming from Dallas, because he was living in Dallas then, and then he had moved to Boston as well. And so I'd say, "Oh, Peter's coming for the weekend. Why don't you, come for dinner, and then you can see my son." And so all of a sudden, he was like inviting like any men friends that I had, and he'd say, "Oh, come to Boston, and we'll go to this bar and that bar, and oh, I'll fix you up with some people and stuff." And I'm thinking, thanks a lot, Peter, but it's just the way it was. And so he spent hours on my computer, and he's a whiz on computers. So I knew that he was hacking or copying or manipulating or sharing my personal information with Scott and Irene, because it was like a triangle. It was a trio of the three of them. And so I knew that there was some thieving there. And the last time I saw Peter actually was, and this is the child that I got full custody of, and who testified in the bankruptcy trial, and in the divorce trial, actually, he testified that he absolutely could not live with his father, and that if he did, he just couldn't even live, because his father was so irrational, and so punitive, and so just mean. And to Peter, actually, they didn't get along at all. But when he was a witness in the bankruptcy trial, which was in a federal court in Tampa. He was Scott's, my ex-husband's, key witness. And they wanted him to deny his testimony with the family law judge in Chicago. And at that time, Peter went to the family law judge and said, I have to live with my mother. I can't live with my father. And she allowed that to happen. And so, because the bankruptcy judge, I know this is getting a little confusing, but it's really not. I had to file bankruptcy, which I talked about in other videos. And I did that because I received a $10 million judgment for a letter I had written, which was, I had written it in order to save my life. And I had written it because I was being tracked and followed and stalked, and there was an attempted break-in, which the police had told me looked like it was a very professional job. And so I had met with other law enforcement, and they recommended that I actually just, that I really think about leaving Chicago and relocating. And I did that. And then there was a trial. He sued me for defamation. And there wasn't one word of defamation in that letter. But I ended up receiving a $10 million judgment. And that $10 million was for future earnings, because what he said is he lost his job over that and had become unemployable because of the publicity that the letter that I wrote had received. And in fact, it was, the front page news. Anyway, I won't get into that. But there wasn't one word of defamation in that. It was all very truthful. So I had this judgment, and that was Scott's way of worming his way into my inheritance. So my attorneys had said, why don't you just file bankruptcy? And as you file bankruptcy, the judge will just allow that judgment to go into bankruptcy as well, and then you'll be rid of it. So I did file bankruptcy in Tampa in 2009, and the judge said, well, I will allow it to go into bankruptcy and you'll be rid of that if I really believe that you wrote that letter because you were terrified. And that's why you wrote the letter. And that's the honest to God truth. And because Peter had actually testified in the divorce trial years before, 10 years before, that he was afraid of his father, that he was afraid of his father for me. And we were both terrified because his father raged and did some other really crazy things. But in any event, that was the only reason I'm bringing that up, is because the judge decided that she would subjectively decide if, in fact, the judgment would be excused in bankruptcy. And Peter was the star witness, and I thought he was going to tell the truth and say, look, in the family court matter, I told the judge that I was afraid of my father and that I was afraid for my mother from my father. And we even had a copy of the certified court transcript, which showed that's exactly what he said. And he went on and really explained, I guess when he went to Aspen with his father had taken all the luggage and turned it upside down and was turning furniture upside down. And what was the other thing? Oh, he took a Bible and I think was like ripping it all up. Anyway, so that's what I assumed Peter was going to say. So what happened was, all of a sudden, during this deposition, it was a video conference, and I saw Peter. I was in my attorney's office in Clearwater, and Peter had flown from London because he had moved to London. So he had flown from London to Chicago, and he was in his father's attorney's office. And all of a sudden, as soon as they showed the camera, I saw Peter, and I hadn't seen him in a couple of years from then. That was, I think, 2009, and I think I saw him 2007 or 8. I don't know. Anyway, I was so excited to see him. And all of a sudden, he said, I don't want to see her. Turn off, move the camera or something. So he didn't want to look at me, and I thought, that's really strange. Why would he do that? And then after my attorney started asking him questions, I understood why, because he didn't want to look at me after he was saying, "Oh, I wasn't afraid of my father, and he never threatened my mother, and no, I never said any of that." And my attorney kept saying, "But Peter, here's the transcript. This is what you said." And he said, "No, I never said it." Because of that deposition, the judge said, "I don't really believe that you wrote that letter because you were afraid." And in fact, she said something which was, I couldn't even believe it. But she said, "Well, you're sitting in my courtroom, so obviously he didn't kill you." And so, and I might not have those exact words. It's been a long time since I've looked at that transcript, but that was the gist of it. So she didn't allow the judgment to be excused in bankruptcy. So I had still a $10 million judgment that like went up $1 million a year or something like that. I think now it's about 50. And it was the exact amount that was in one of my father's accounts. And so we knew that that whole thing was just an avenue by which he could go in and start stealing my inheritance, which is exactly what he really wanted. So the last time I actually spoke to Peter was subsequent to that. It was after I had lost everything, when I realized, because of the fake documents saying that I was written out of everything, and all of a sudden everything went to Irene and Peter. I called him and I said, "Peter, where am I going to go? You've taken everything. I mean, because of you, I've lost everything. And if you want my condo so badly, I'll give it to you. You can have the title of it, but I need a place to live." And what he told me is not to bother to call him and to call his attorney instead. And so in that moment, I realized that I actually was homeless, and that no one on the planet whom I had done so much for gave a damn. And I know I'm not the only person around that has had that really horrible realization that all of a sudden, we give and we give and we give and we love and we love and we love. And yet, when all of a sudden we need something, we need help, the people that we relied on so much, that we unconditionally loved, that we considered um, our closest our closest loves. I mean, a mother and her child is just a beautiful thing, or a mother and a woman and a man, or a woman and, nowadays, anyway, two people, right? And so I realized that I was going to be a homeless, destitute person because of my son's testimony. And so I thought, there had to be a purpose for it, right? Of what I was going through. And the purpose perhaps had to do with exposing what so many of us struggle with. And for me, it was loss after loss after loss in the legal arena of everything that I knew and everything that was important in my life, which was actually more than just the things, just the car and the furniture and the antiques and the home. It was actually the people, because once you were surrounded by like-minded people, by people in your tribe, or whatever they call that now, but your family, be it biological or spiritual, once you're surrounded by that, you can pretty much get through anything, right? And so, going back to this, the Third Amendment that they tried to sneak in, and actually they didn't really have to sneak in because no one was going to stop them, right? I couldn't get an attorney that was going to help me. So, and I didn't even know most of this was going on. After my parents died, no one would answer any phone calls. So Irene was listed as trustee. There was no Maria and Irene, it was just Irene. And her husband, Alan, and Tom were backup co-trustees. And so in the real will, it was Maria and Irene were co-trustees with equal power and control, right? And Alan was backing up Irene and Tom was backing me up. And so, but all of a sudden in this will, there was no Maria. So I guess Tom would have backed up Peter. But the whole thing was just ridiculous anyway. And that was also true for being trustees, being personal representatives. So you might ask, who deleted me as beneficiary of the entire estate, right? It was 50-50, and then I had those titles. Who all of a sudden can just white you out, right? Or erase you or scratch you out or whatever it is that they did? And the answer is that it was Irene, because in this bogus Third Amendment, she wrote, if my mom were incapacitated, she gave herself the power to change the documents. So I just find that just a little strange. I don't know if you do. Yeah. So that's kind of interesting, isn't it? So all of a sudden, my mother was incapacitated. Irene and my father Irene had actually talked my father into putting my mother in a home, and the more she was in that home, the more incapacitated she became. But as that happened, all of a sudden, Irene's power um, just crescendoed to heights I can't even imagine. And then Tom, the attorney cousin, he mysteriously dies in 2021, and that was about the time that I was beginning to expose some of the crimes in my 60 plus Forgiveness to Love videos that I have. So there were a lot of really weird things going on. And so I was planning a trip to Florida to meet with him. And when I arrived a little over a year ago, I drove to his law office, and I was shocked to learn that he had died. But I guess a lot of people were dying of COVID and things like that. I don't really know. But I couldn't get much information. Irene and Alan. Basically, the two of them took control of the entire estate. And so, again, this fake will was drafted on Christmas Eve 2006 and not filed until 2013. So then we have the Third Amendment to the last will and testament. So what they did is they added this Third Amendment, which had all of these crazy things where delete Maria and just put in Peter wherever Maria's name was. And they also attached that to the will. And the will is what we had seen, which showed that, again, Maria inherited number 417 and Irene inherited 414. And it was the spendthrift clause. And they were trustees, co-trustees, and they were co-personal representatives. All of that, all of a sudden, this third document, this Third Amendment, just appeared in both documents now. So it was attached not only to the trust, but it was attached to the will as well. And so let's talk about the general duties of trustees, because I think a lot of people don't really understand exactly what a trustee is allowed to do. Because after my mother died, and shortly thereafter, about 3 weeks later, I had scheduled a trip well before my mother was being starved at the time. I had scheduled a trip to Brazil, and I only wondered that's why they had my mother starved, because I was going out of the country just for a couple weeks. Things could have gone on behind the scenes while I was out of the country, right? And so anyway, let's talk about the general duties of the trustee per the Florida Bar, which is to distribute trust income and or principal to the beneficiaries. Well, no one would even talk to me. And to keep records of all the trust transactions, and to give statements of the account and tax reports to beneficiaries, and to answer any questions the beneficiaries might have. Well, I had lots of questions, but no one answered any of them. In fact, no one would return my calls, answer my emails, answer Messenger, answer Facebook communications, answered their door, even when I went knocking on their door. Nothing. And so the same goes for their attorney as well, because I did email and call and never received any communication back from him. So technically, Irene and I were still co-trustees per the real document, and I don't believe for a second that, in fact, my parents had anything to do with these new documents that were filed just kind of on a whim, I guess. Let's just blacken out Maria, right? and we're just going to put Peter in, and then it's going to be Scott, Irene, and Peter taking over the whole estate. So it's basically it was one a daughter, Irene, um, and one grandchild, Peter. Meanwhile, there's another daughter, me, and there are three other grandchildren. I have four children in total. So my other three children weren't in the will, other than to get $1,000 like I did. Meanwhile, there were millions and millions that they were to get from their grandparents, and that was exactly their grandparents' intention, which was to equally divide it, if in fact something had happened to me. But because nothing did happen to me, it all was to come to me, my 50%, and then I could distribute it any way I want. Because after all, when someone passes, it doesn't automatically go to the grandchildren, right? It goes to the next generation. It goes to your daughter. It went to my parents' daughters. And then however I want to distribute it is how that would go. In any event, the trustee has a fiduciary duty. It's a responsibility to distribute the estate assets to the trust beneficiaries and to ensure that the beneficiaries are paid. So the trustee also has a responsibility for managing the trust assets and carrying out the purposes of the trust. Trust documents, trust instruments are generally written so that there would be simple distribution of the assets. It's very clear cut, or it should be. So Irene was to answer all these questions. She was to give me documentation of the taxes and of all the receipts that she was paying, and the trust inventory. We heard in an earlier video that there was no inventory and there was no accounting. So we didn't know if the estate was worth what, $50, $50,000, or $50 million, right? Because there was no accounting. It was not filed with the court. And in fact, the judge had discharged the case when Irene's attorneys kept postponing it and getting extensions and extensions to file. So ultimately, there was no accounting. And the estate was so vast, and my father had so many assets. It wasn't just what was in some investment account. I mean, he had a lot of other investments as well. And so where are they? Where is anything accounting? Where's the accounting? Where's the inventory? I've never seen it. As far as I'm concerned, my sister totally and deliberately failed to carry out her trustee responsibilities. She totally and deliberately failed in that regard, as she was taking things and not writing it down, right? So we have no idea what has slipped through their fingers, although we don't even have a skeletal inventory. And so there are no records of the trust, and certainly I never received anything. And a trustee must put the beneficiary first. This is part of her duty. She must put the beneficiary first and cannot take advantage of the authority vested in her as trustee. So she can't take advantage of being the trustee, even though she's really a co-trustee with me. But nonetheless, in the worst case, we could say she was a trustee. However, because I could still be the beneficiary of 50% of the estate, which is exactly what I'm supposed to get, right? And she is to put the beneficiary first. She can't take advantage of the authority vested in her as a trustee. And one of the articles I read is that when the family is a trustee, it's like a ticking time bomb, because the trustee can be influenced, right, by another family member. She could be influenced by Scott. I'm sure she was. She could be influenced by Peter, or they were all influencing each other, right? Or for her own self-interest. And that's part of her duty as a trustee. My sister refused to answer any of my calls, messages, letters, or any attempts to contact her. And I even went, when I came to Tampa a year ago, and I was just going to stay here like a couple weeks because I thought I could read through all the documents and just figure this out. It didn't happen. I actually went to her husband's medical office, to Alan's medical office. And he didn't see me, wouldn't see me, couldn't see me, said he wasn't there. I don't know. I didn't see him. So then I ended up a different day. I went to their home right across the street from the hospital. And I went to their home and I knocked on the door. And all of a sudden, um, Alan opened the door, and I think I said this in one of my videos because it reminded me of the Addams family, where like it's like in a haunted house where it's kind of creaking. Well, he opened the door and it was really, really slow. And then he looked at me and then he closed the door. And I said, Alan, I mean, I had known him so well for all those years that that I had known him when he was at Northwestern and I was at Northwestern. I mean, we'd known one another all those years, and the four of us would go to dinner quite a bit, and we spent quite a lot of time together. And yet he closed the door on me, and I thought, wow, that's really strange. And I wrote him a letter and I dropped it off at his office. And then I wrote another letter, dropped it off at their house, and I said, please have Irene call me. I'd like to discuss the estate that she and I are co-trustees of, and she and I are co-personal representatives of, and she and I are co-successor trustees of, and we're sisters, and our parents were just so clear in saying that one was not going to have more power over the other at all. And so again, we talk about the duties of the trustee, and so they have fiduciary duties. I thought this was interesting because it says the most basic duty of a trustee is the duty of loyalty, which obligates the trustee to put the interests of the beneficiary first. So even if she wants to say, oh, forget it, you're not a co-trustee. Well, who is she to even say that, right? However, even if she did say that, I'm a beneficiary. There's no way that my father would have given one of my children everything and left me out on the street. That's just more than ridiculous. And so it said the trustee is to put the interests of the beneficiary first ahead of her own self-interest, and to refrain from exploiting the relationship for the trustee's personal benefit. I'll tell you that again. And to refrain, so to stop exploiting or to not allow themselves to exploit the relationship for the trustee's personal benefit. And yet she violated virtually every aspect of her duty, as far as I'm concerned. As a trustee, to me, clearly she put her self-interest above each and every beneficiary that I'm aware of. Certainly my 3 children have lost, right? Why in the world would my 3 children lose to their one sibling? I mean, it's such a flagrant example of corruption. It's just ridiculous. And so then Peter ends up getting my home and everything in it, right? And then that Irene and her attorneys say that Irene and I are tenants in common. And yet, well, we already went into this, right? Irene gave my 50% of my parents' condo to Scott, right? So then I lost my home again. And yet, per Florida law, you can't lose your home to a creditor. And so there's no way that even as if I were only going to get half of my parents' condo, there's just no way that she would be able to give my 50% of that condo to Scott. And yet she did. It went to a sheriff's sale. He bought it for $100, sold it for $500,000 or something like that. I don't know. I do have the exact numbers written down, but not by memory, because it sold, I think, 6 different times or something like that. So because in Florida, there is a loophole which protects you and keeps you from losing your house, from creditors, and even the IRS. So again, Irene totally cheated me. Irene and her attorney said that I actually lived with my parents and that I was their caretaker. So that's why she gave 50% to Scott, supposedly for partial payment of the defamation judgment without informing me of anything. That's just ridiculous. That was the loophole. In Florida, you have that loophole, and yet we didn't take advantage of that at all. My condo that my father had bought me in 2004 was actually empty for 9 years, from 2004 to 2013, because Peter was in the UK, right? And I certainly was living there. It was my house. He would come and visit me, and other relatives would come and visit me, and other friends would come and visit me. And it was down the hall from my parents. And so that's just the most ridiculous thing, that all of a sudden it was empty and I was living with my parents. That's like beyond crazy. And plus, and Irene and her attorney said that in fact, they knew of only Peter being the beneficiary to receive my condo. And in fact, that they never heard that there was to be anybody else that would inherit 417. So they were saying basically that, yeah, I didn't exist. Because they said I was just, there was no one else that was to inherit 417. And I lived there all those years. I lived there nearly 10 years. And it's just so shocking. It's really, I feel like I'm in the Twilight Zone because it's just so crazy. And the original trust, we've gone through this now, but the original trust said that the entire trust goes to Maria and Irene and share alike, and their successor trustees. And then there's the spendthrift clause, which says that Scott judgment can't take any of my inheritance, and that we're 50-50 beneficiaries of everything. And so it's like there's just no question. It's just unbelievable that in fact you can actually just all of a sudden add like 4 years after the last parent dies, right? Because my mother died in 2011, and some of these documents weren't even filed until 2015. So all of a sudden, now you've got 2 condos, and one was to go to one daughter, the other one was to go to the other one. Instead, one went to the son, and the other one had a sheriff's sale. And due to the sheriff's sale, it went to an ex-son-in-law. I mean, it just doesn't make any sense. Really, it just doesn't. And both condos were to be just paid off. And so it's not as if there was any type of a mortgage where the payment was due, because it said that the corpus of the trust was to pay for all the expenses related to the 2 condos. And so unless that fake address, unless that wrong zip code and the wrong address for my condo, unless that was one of the ways that they were going to say, oh, well, we never got the bill, so all of a sudden it went into default, and then we had to have a sheriff's sale, and so otherwise we would have paid it, right? But because, it was an incorrect zip, all of a sudden, we're not going to pay the bill, or didn't pay the bill, or whatever. Anyway, it's so ridiculous. And then all of those, the art that my father had, and then the crystal and the sterling and all of that stuff, which was to go 50-50, it went all to my sister. And, because I had mentioned before, because my father was saying that, in fact, he didn't really trust Scott and Irene because he knew that they had keys to my condo. And so he encouraged me to bring a lot of my valuables and store them in his extra bedroom and in their walk-in closet. And I had done that. And so all of a sudden here it says that Irene gets 414 and Peter gets 417. So my possessions that were in 414, I lost them to Scott, actually. because he got my 50% of that. So the whole thing is just it's like um, a big cauldron where you just see like all these crazy people just mixing everything up. It's just the most ridiculous thing. And there was also one other thing, which was that there were some assets in a Merrill Lynch account, and there were two IRAs. My father had an IRA, and my mother had an IRA, and so my father had shown me this statement of one IRA, and it had significant sums to the effect of $3 or $4 million in it. Then, like in 2004, I think he showed it to me when I first came here, and when Scott started to sue us. And so my father said, I just want you to know that this is in my Merrill Lynch account, and I am writing you a sole beneficiary. So regardless of how many lawsuits Scott does, he's not going to be able to hold up your getting your inheritance, because I'm going to give this one to you, and he can't touch an IRA. So, and he said, I've already filled out the paperwork. My broker already knows that it's yours, and that you're going to get that, and you're going to get all of the possessions that you had assigned to me before the bankruptcy, before anything is divided 50-50. And you know what? I've never gotten it. I actually went to Merrill Lynch, and I asked for it, and they said, well, you need to have an ongoing lawsuit, and your attorney can subpoena the files, because we do see very large sums in some accounts here. I do believe there is that IRA that belongs to me. It could have gotten me out of living in a car for 9 months, right? Or being homeless and destitute and broke and hungry for quite some time. And yet that was there. And so, again, I couldn't get representation because I was told that no one was allowed to help me. No one was allowed to represent me. And I'm not sure in the entire state of Florida. So I'm not sure exactly how that happens, but it happened to me. The goal is not to bemoan all of this that's going on. It's a legal issue, right? And in lawsuits and in litigation, crazy things happen, right? Things that we don't understand, things that we don't want to understand, things that we can't even believe are going on. And so, therefore, I pray that you've been able to get some golden nuggets from just today, when I really wanted to focus on the will, the original will, and then all of a sudden the second will that showed up, and then the original trust, and then all of a sudden the Third Amendment that showed up. And so I hope I've put it in a way that is understandable and manageable for you. I think, let's see, we're going to figure out some other really interesting things to learn about. All right, we'll move on.